I don't know, and perhaps even more significant, if you read the transfer of the case, he basically told the plaintiffs to change their case. They brought it one way. He said, "No, here, plead it this way." Okay, good. Now I'm going to certify class and issue a ruling and go tell the plaintiffs around. He basically litigated the case on behalf of the parties. This wasn't merely a passive bystander; he was an active participant.
It's a statistic and possibility. And I want to I referenced what had been going on in the Eighth Circuit. 10 of the 11 appellate judges in the Eighth Circuit appointed by Republicans. Amazingly, Judge Kelly ends up on all the politically sensitive cases on a panel. It's not possible, except for the clerks there in that office, or the people that work for the clerk's office, are populated by her former clerks. So these are the kinds of things that this isn't just a new phenomenon. This is a concern about activism on the bench that's existed for a long time. It's just now on steroids. You talked briefly, and I mentioned it too, sort of Rule 23 as a more viable option for this, limiting the limiting the orders to the parties, the rulings to the parties before the court as a case in controversy. Those are ways to address this. Are there any other structural suggestions that you have? And I also want to pose this to Professor Elisea as well.
Sure. I think one urgent need is to think about automatic stays. When you have district court judges granting universal injunctions and they don't stay their rulings, there's this frantic race to the Court of Appeals and to the Supreme Court. And the executive branch is not capable of actually changing policy on the fly. And that gives rise to these attempted contempt proceedings. I would think about if a universal injunction is granted or a nationwide class is granted, stay the ruling for 24 hours, 48 hours, some limited period till he's taken appeal to the appellate court, and don't let the judge just ruled against you decide whether appeals to be taken. I think the automatic stay will go a long way to addressing these issues.
Professor Elisea?
I think beyond Rule 23, and the enforcement of Rule 23, it's important to address the scope of injunctions not just through the non-APA route, but also through the administrative procedure route under Section 706. So I think that to the extent that we're going to really address the problem overall, you can't just address universal injunctions that are done outside of the context of administrative action, but also through the process that the APA sets up for challenging agency action.
Thank you. Professor Blackman, I do want to, you recently wrote an article in May of this year where you state the District of Maryland's standing order, that judge that automatically blocked deportations upon filing a habeas petition without merit review, is pretty clearly designed to thwart the Trump administration's immigration policies. Could you explain that?
Yeah, this is unusual. So the District Court of Maryland issues what's called a standing order, which is basically an order that applies in all cases. And it says, by virtue of filing a habeas petition, a grant of stay is automatically issued. The Supreme Court has said there's a four-factor balancing test to decide whether a stay must be granted. This is automatic. Indeed, if you actually read this seriously, it's a permanent handcuff on the president's authority to deport people. The judge actually walked it back about a week ago. They sort of modified it. Maybe the judicial conference got wind of this. But I think there's still an attempt to limit the executive power in ways that have not been done before.